The Section 194 inquiry into suspended public protector Advocate Busisiwe Mkhwebane's fitness to hold office this week resolved to adopt the final report recommending her permanent removal. The committee said it found conclusive evidence on the charges of incompetence and misconduct at the hands of Mkhwebane, whose tenure is expected to end in October. At the same time, interviews for the 8 shortlisted candidates took place this week, and this is anticipation of one of those possibly taking office in October. We speak now to Tanveer Jeewa, constitutional law lecturer at Stellenbosch University. Tanveer, thank you very much for your time this morning. Perhaps let's take a look at whether this passes the legal muster, if there's such an expression. I guess I'm asking in terms of, should this be taken on review and the public protector decides to go the legal route, would she have a case?
Thank you so much for having me. So I guess the first thing that we need to speak about is obviously the role of the committee itself, right? So under the National Assembly Rules 129, 82, it states that the committee should ensure that the inquiry is conducted in such a way that is reasonable and procedurally fair, and very importantly, for the purposes of what we're speaking about, within a reasonable time frame. So if I were the public protector and I would be bringing this report under review, I would probably be doing so on grounds of procedural fairness, because as you know, she's already made allegations of bribery against the chairperson, but that does not necessarily guarantee high prospects of success. I would have a hard time finding any court being in agreement with her, because before the Speaker had already referred the issue of bribery to the Ethics Committee in Parliament, and I, as a court, I would ask, why not challenge the process of the Ethics Committee itself as opposed to this inquiry? Because on the basis of the inquiry of the committee alone, they've bent over backwards to try and accommodate suspended public protector Mkhwebane, right? She's delayed the process quite a bit. I mean, this motion was put into place in February 2020 already, and we are now in August 2023, where this has been finalized. So she can bring it to court. It is a final report. It wasn't a report done by a court. It's an investigative inquiry. So she can review it on procedural fairness and some other grounds that maybe she can bring up. But I have a hard time finding her actually winning a case like that.
Okay, the bribery issue aside, you speak of procedurally fair in terms of the scope or the mandate of this committee, that being one thing. And you say the committee has bent over backwards. How so? When she has also consistently pointed out that she did not have legal representation, more so towards the end when she got these written questions. Procedurally, is that fair?
Absolutely. So that's a great question, because we need to also look about what she's alleging when she's talking about not having legal representation, right? Because she's had legal representation in the form of different attorneys and then Advocate Kholeka for the very long beginning. And then in the duration, she kept there was either an attorney that was sick or she was firing her attorneys didn't want to represent her anymore, at which time the committee was always giving her time to find other attorneys to replace the attorneys who had left before that. So when I talk about bending over backwards, I'm referring to the space of time of 2 years, which has accounted for giving her time to actually get legal representation. It's only towards the end where she was given a right to reply, and she was given 10 days to respond to the pending report before it was finalized, and she did not respond because she said that she was having new attorneys and she needs time to actually brief those attorneys so that they can speak to her advocate. But what I want us to think about is who exactly is paying for these legal fees, right? We're talking about legal fees in the millions over a span of 2 years. And I want us to highlight that the legal fees have been paid by the Public Protector's Office, right? Taxpayers' money. And we're looking at millions in briefing senior counsel. And we need to talk about the reasonableness of that kind of measure, right? Having that amount of money going into such an inquiry. And she's then alleging that she doesn't have the right, she didn't get a right to legal representation when she's consistently has had attorneys and they've given her the chance to even replace those attorneys. But at some stage, we need to take a step back and realize when something's being a delay tactic. So I would not agree with her statement about them being unfair and not giving her legal representation. I think they really did what they could.
And how to prove the allegation of a a delay tactic, right? Because when you speak of the reasonableness and the kind of money that has gone into this inquiry, she did not ask for the inquiry. This inquiry was brought upon her, right? And she has mentioned that even though she hesitated, she has presented herself at every turn of this inquiry. And so does she also not enjoy the constitutional right of having this process being procedurally fair, with the reasonable time frame, all these factors that we have spoken about that have presented themselves in terms of challenges? This could have happened to anybody.
Absolutely. I think you're incredibly right over this. Of course, even in representing herself, she has the right to represent herself in a way that is just to her, for her to get justice, and also in a way that defends the institution of the Public Protector's Office, right? You're absolutely right. The Public Protector's Office itself needs to be able to put forward good legal representation so that in case this motion was actually not well put and the grounds on which she's being charged of misconduct or any other grounds, if they are not valid, they should absolutely be tested. But I think that's the whole point of having an actual balancing exercise and considering different factors, right? When we're looking, I mean, we have to be honest, this is the first time this is happening in South Africa. So maybe there are different ways that we should have tackled this. Maybe there should have been, other than saying reasonable time frame, maybe there should have been a deadline put to this process. But the reason I'm putting this forward is we must also be fair in assessing what's going on, right? Public Protector Mkhwebane's tenure is going to end on the 14th of October. If the tenure ends and she's still in office, she benefits of a bonus. And maybe we need a bonus of millions. We have to talk about that again. And we need to talk about what maybe the delay tactic has a reason for existing. But at the same time, as you said, she also has a right to fair legal representation, to just legal representation, right? And that's what, for a court to decide if she does bring it to court. But she would have at least a threshold argument which would allow her matter being heard in terms of alleging that the right might have been infringed. So I am on you with that, in that we would need to actually take a step back and assess how to prove a delay tactic, as you mentioned.
Because like you rightfully mentioned, this is precedent setting. You wanted to get into the issue of her receiving what is due to her should she finish her term in October. Why?
Because I think there has been, we need to take into account what the different opposition parties have also been mentioning, because obviously they have a ground of opposing such matters as well. So the reason I'm mentioning this is because we have to talk about the fact that this resolution has been put into place in February 2020. We are 3 years down the line. So we have been trying to, or rather whoever has put the motion, which is Chief Whip DA in this case, has been trying to get the public protector removed on pretty valid grounds. And the reason I say this is because we have almost 3 constitutional court judgments talking about her misconduct or her incompetence with respect to a few things that are pretty basic on a level of a public protector. And if we've been trying to do this for 3 years now, and she still gets to finish her tenure, although there is a finalized report that says that the findings are indeed that she has, there are grounds of misconduct and incompetence, then should you really be awarding a bonus of that level, which again is taxpayers' money, to someone who has actively undermined the office of the public protector? I'm trying to be fair in assessing this and very much in still saying that the public protector should always have the opportunity to defend herself and to defend her office. But I also want to point out that this is an opportunity that she's complaining about that she hasn't even afforded a lot of the people that she's investigated in her reports, right? This is something that was actually brought up as a ground of incompetence. So I want us to assess all of this in light of whether you want to give that bonus to someone who's actively undermined the office of the public protector in her tenure.
Yeah, again, how to prove this, that she's actually undermined the office of the public protector? Do we not, Tanveer, need to be vigilant when it comes to the office of the public protector, right? Either as policymakers, as the layperson, as the general public. When you take a look at the tenure of previous public protectors, whether it was used for political gain or disdain, whatever it is, the public protector's office has not gone incident-free, if you will, in terms of it being used by certain sectors of the population to advance their own narratives. And so do we not need to be vigilant? Because this is not only precedent-setting, but tomorrow it might be one of these 8 public protector potentials that are facing the situation again.
Absolutely. And I think I would agree even to go to the point of saying we need to be very careful, precisely because in 2017, there was a constitutional court judgment that says that the public protector's reports and findings are now binding, right? In effect, kind of making it a court in and of itself, and you need to actually appeal those reports. So we need to have discussions about who exactly is the public protector, how do we actually interview these public protectors. You've mentioned the 8 candidates that were currently being interviewed for the position, but also it being precedent-setting. I think the Section 194 committee and the process, having run through its whole duration, having been questioned at every turn, taken to court, having court actually pass judgment on the validity and constitutionality of the process is very important because, like you said, it sets precedent and it makes sure that in the future we actually know what the process looks like. So if I were Public Protector Mkhwebane, I would act very urgently, right? I would 100% challenge the committee's report if I do believe that it's a report that wasn't procedurally fair and that there were other issues. I would challenge it right away because this is the very same report that the National Assembly has to debate and has to vote on in order to take a decision to actually remove her. So I would make sure to actually stall the report right now and actually challenge it. And even for the constitutional democracy that we have, it would be important to have a challenge like that because, as you mentioned, it's precedent setting. And as well, we actually know the validity of a report and whether there were any grounds of unconstitutionality, which she seems to challenge that there is actually, right? So I would agree with you. It's 100% important. And we also don't want to be biased in what we believe Public Protector Mkhwebane did or did not do wrong. We need to assess the whole process quite holistically.
Okay, just as we close the conversation, what stood out for you if you managed to catch the interviews this week?
I think it was very interesting. The questions were quite thorough in terms of the legal precedents and just legal principles generally. But what I wish had happened a bit differently was more questions about things that led to the suspended public protector being found to be, or rather having allegations of incompetence, right? So things like not giving the right to reply and actual concrete things of what it entails to be a public protector and the things that where she went wrong and the Constitutional Court found her to go wrong. Other than that, I think that most of the candidates were quite good and that the questions were thorough, and hopefully in assessing whether they would have done things quite differently and knowing the different processes, we can now get an incumbent who also, reinforces the legitimacy of the institution, whether it's credible now or not, but in any event reinforces the credibility of the institution.
Thank you so much for your time this morning. Much appreciated. Constitutional law lecturer at Stellenbosch University, Tanveer Jeewa.